started. We do not have the attorney yet for Mr. McMullen, but we have the counsel for everybody else, so we'll just go ahead and get started with the final pleas for those people. Are there any guilty pleas that are going to be tendered today by any of the any of the defendants?
Yes, Your Honor. Anastasia Smith on behalf of Mr. Miles Farley. We have a plea of prison support.
All right, why don't y'all come on up to the podium, please? All right, Mr. Body, whenever you're ready.
For the record, this is yeah.
And everybody, I'm just going to give a reminder to just use the mics. They're in front of you and they're mobile, so you can move them up close so that everybody can hear.
This is indictment number 22 SC 183-572, State of Georgia versus Mr. Miles Farley. Mr. Farley, if you'll please raise your right hand. You solemnly swear and affirm that the testimony about to give the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
Okay, put your hand down. Could you please state your true, correct, and legal name for the record? I'll let you sign before I ask any more questions. So I'll choose if you want.
And Mr. Body, maybe reposition the mic while he's doing that.
Yes, Judge. Mr. Farley, could you state your true, correct, and legal name for the record?
Miles Farley.
And Mr. Farley, are you at this time taking under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here?
No.
And how old are you, sir? And how far have you gone in school?
You sit. I got a bachelor's degree.
And are you able
Can you
to?
also speak into the mic, please?
26 and got a bachelor's degree.
And sir, are you able to read, write, and understand the English language?
Yes.
And do you understand you are charged in indictment number 22 SC 183-572 with count 1, conspiracy to violate RICO, count 49, which is related to the homicide of Mr. Drinks, counts 50 and 51, which are both participation in criminal street gang activity, and then count 54, which is a possession of a firearm in the commission of a felony. You understand you're currently charged or indicted with those counts?
Yes.
And do you understand that you have the right to plead either not guilty, guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes.
And has your attorney, Mr. Menendez, gone over the rights that you're waiving by taking a guilty plea here today, sir?
Yes.
And are you satisfied with the services that your attorney has provided?
Yes.
And do you need any additional time to talk to your counsel about any of the facts and circumstances regarding the charges and the circumstances of this case?
No.
And Mr. Menendez, do you waive formal reading of the indictment?
So waived.
Do you waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this hearing or plea?
Yes, so waived.
And Mr. Farley, has your attorney spoken to you about the minimum and maximum penalty for the counts that you're pleading guilty to?
Yes.
And he advised that for count 1, RICO, the minimum is 5 years, the maximum is 20 years?
Yes.
And do you have any questions as it relates to that count, the single count that you'll be pleading guilty to?
No.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will offer a joint recommendation to the court as to the sentencing recommended for the count that you're pleading guilty to, but the court does not have to follow that recommendation, and she can sentence you as she sees fit up to the maximum for the charge.
Yes.
Do you have any questions about that?
No.
Okay.
Is he just pleading to count one and y'all are null processing the rest as a part of the agreement?
That's correct, Your Honor.
Okay.
Now, do you understand? Mr. Farley, do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else?
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty here today, sir?
Yes.
Do you also understand that by pleading guilty, you're giving up or waiving the following rights? The right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges proved against you beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Do you understand by taking a guilty plea here today that you're waiving or giving up all of those rights?
Yes.
And Mr. Farley, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
And are you pleading guilty, sir, because you have decided in speaking with your counsel, Mr. Menendez, that you believe that it is in your best interest to do so?
Yes.
And are you aware that even if you're not admitting guilt, as you're pleading under North Carolina versus Alford, if the court accepts that this plea of guilty places you in the same position as if you were convicted after a jury trial?
Yes.
Okay. And how do you plead to count one, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act in indictment number 22 SC 183572?
Guilty on the outset.
And Mr. Farley, is this Alford guilty plea freely and voluntarily given with full knowledge of the charge that you're pleading guilty to?
Yes.
And do you understand that you may have a limited right to appeal this guilty plea conviction?
Yes.
Do you also understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Challenging anything about the constitutionality of the guilty plea, understand?
Yes, Your Honor.
Well, I want to make sure he
Yes,
does.
ma'am.
All right.
Do you also understand, sir, that you have 30 days from today to file a direct appeal from this guilty plea, and until the end of this term of court to file a motion seeking to withdraw this guilty plea, which doesn't mean that the court necessarily would grant it or not. It's just that's the time constraints that you have to file under those areas of the law.
Yes.
Okay. Do you have any questions about that?
No.
Okay.
All right, and your attorney, Mr. Menendez, will represent you until 30 days from now or the last day of this term of court, whichever is later, and he would be the one to file any of those things on your behalf unless he is allowed to withdraw before that time. Understand?
Yes, ma'am.
And just so the record's clear, I just provided to Ms. Percival the indictment, which was signed by all parties as it relates to
All right.
the defendant's guilty plea to count
Thank
one conspiracy to commit RICO. Your Honor, had this case proceeded to trial, the state would have shown beyond a reasonable doubt that between January 24th of 2013 and May 8th of 2022, this defendant, Mr. Farley, in conjunction with his fellow co-defendants, co-conspirators, known YSL associates, did unlawfully conspire to conduct and participate directly and indirectly in the enterprise YSL. In doing so, they did it through a pattern of racketeering activity, conducting and participating in YSL with the same common objectives, which were to preserve, protect, and enhance the reputation of the enterprise, that being YSL, doing so by protecting the power and territory of known YSL strongholder areas through acts of violence, also through other means such as social media, posting messages, images, and things of that nature. That's what the state would have shown as it relates to Mr. Farley and his involvement as it relates to the enterprise YSL and his association, Your Honor.
All right, I assume at least some of the evidence would have been the same as or similar to what was presented at the trial of some of the co-defendants that just was completed a couple of weeks ago.
Yes, Your Honor, very much.
All right, so I'll take that into consideration with regard to the factual basis as well. All right, anything else from the state?
Nothing further. The recommendation as it relates to, or the joint recommendation that the parties would make to the court, it's my understanding that the defendant obviously would like to tender his plea under North Carolina versus Alford, and I neglected to ask Mr. Farley, but it's also my understanding he qualifies for the first offender treatment, and he is asking that the court treat him as a first offender, which the state has no objection to either, and the recommendation would be 5 years to be served on probation.
All right, Mr. Farley, has your attorney discussed with you the First Offender Act and what all that means?
Yes, ma'am.
All right, and have you all discussed the potential upsides and downsides of that?
Yes, ma'am.
You understand that if you successfully complete, if I sentence you in accord with what has been negotiated, if you successfully complete the probationary time without having any violations of your probation, that at the end of that, you would not be a convicted felon. Understand?
Yes, ma'am.
All right, you understand as well that if you do not successfully complete that probationary period and your probation is revoked, that not only could you be revoked for that 5 years, but the court could actually adjudicate you guilty, find you guilty, not under first offender, but just straight guilty, and impose up to 20 years imprisonment for the count to which you are pleading guilty under Alford. Do you understand that?
Yes, ma'am.
All right. Mr. Menendez, is there anything else that the defense would like to place on the record?
Yes, Judge, I just want to add a little bit of nuance to the plea in case the court's not as familiar, because a lot of it was on the front end. Mr. Farley is an HBCU graduate with no criminal record, and it's actually his marketing and his genius work as a businessman that even brought him into all of this, which is why we're asking the court to sentence us under Alford. In 2019, him and a friend created a clothing item, a hat, that was like a satirical play on the Trump hat where it said "Make America Slime Again" instead of "Make America Great Again." And Your Honor, the clothing brand never said anything about YSL. It was just using this youth term slime, which I'm sure by now the court knows can have many different meanings in many different contexts. Mr. Farley is born and raised in the Cleveland Avenue area, and he does exemplify a lot of the great qualities of the people of that area, his creativity, intelligence, tenacity, his bravery in taking things this far, Your Honor, putting his foot down when he was faced with this, government abuse. But what he did next, Your Honor, is he went to Miles College, and then despite having a vast network of opportunity from his bachelor's degree in business, he returned home because he is a family person. His dad is here in the yellow hoodie in the back. He's also an entrepreneur. That's where Miles gets a lot of that from. And so, Your Honor, when Mr. Farley made this clothing brand, he built off of the hat. In 2020, he made an LLC for Make America Slime Again, and he's actually employed by a record label to be a handler for a musical artist. And then he used those associations and that presence to promote his brand and to have his clothing be as visible as possible. He started making custom pieces for different artists and different people. And Your Honor, if you remember from the evidence that was presented, Mr. Farley's always wearing his own clothing, and he's only ever promoted his clothing for the purpose of himself and his business and his family. And so that's why, Your Honor, I think the most sincere and appropriate way to resolve this case is under Alford. The state, in that respect, did the right thing with its discretion, dropping the murder case. Mr. Farley had nothing to do with the death of Mr. Drinks. And so, Judge, he's been on house arrest. He's been totally compliant. He's not a gang member. He's never committed a crime in his entire life. But he is wearing an ankle monitor. He is confined to his home. It's better than jail, but I think we all know after COVID that that's not necessarily ideal. and he just doesn't want to go to trial. And that's why I think Alfred is a textbook case for this type of situation. And so if the court has any questions, we would just ask this honorable court to accept the plea as negotiated.
Okay, well, I mean, it would be determined by a jury at trial whether his involvement in the case is only because of his marketing and business acumen or something further than that, something criminal. But in tendering a guilty plea under Alford, Mr. Farley, you are admitting that while you do not believe you have committed the crime of conspiracy to violate the RICO Act, you are acknowledging that there is sufficient evidence that the state could present to a jury from which a jury could conclude that you are guilty of that crime. You understand that, right?
Yes.
All right. All right, I find there to be a factual basis for this plea. I will accept it under Alford, and I'll permit it under the First Offender Act. And I find the plea to be freely, knowingly, voluntarily, intelligently entered with an understanding of the consequences. And in accord with the negotiated recommendation, I am going to sentence you to 5 years probation. And as we discussed before, how you perform during the next 5 years of this probation is going to determine whether you finish that. A person who can say that they do not have any felony conviction, or whether you might be spending some time potentially incarcerated. So it's entirely up to you how you comport yourself and how you choose to behave going forward. What ultimately will happen at or before the end of that 5 years. Do you understand that?
Yes, ma'am.
All right. Are there any special conditions to this probation? Have y'all negotiated any?
The state didn't have any real special conditions, obviously, other than follow the law.
Okay. All right. Well, that is the sentence of the court. I need to ask if you have a weapons carry license. Do you have a license? Okay.
No, ma'am.
All right, that's fine. And while you cannot have any firearms during the course of your probation, if you successfully complete all your probation, you would be able to possess firearms again. All right, Mr. Farley, good luck to you. I know that you have a very successful business, and let's just make sure that that business is on the up and up, and that you are following the law.
Mm-hmm.
All right, good luck to you. Thank you.
Thank you, Your Honor.
And is there somebody here from probation?
If he would wait, Miss Jolly is on the way.
All right. Mr. Menadas, wait until the probation officer, Ms. Jolly, can meet with y'all and get all of that taken care of.
Yes, Your Honor.
All right. Yeah, that'll be fine, and after you meet with her, then you are excused. Thank you. All right, are there any other guilty pleas that are going to be tendered today? All right, so what I would like to do is, and we can just start up here with Mr. Mender, and I'd like the state to put on the record what the plea offer is. And I want everybody, all of the 4 defendants, and Mr. McMullen, we just heard from your attorney, and he believes he will be here by 11:30. He's apparently in Gwinnett County on some other case right now, and we'll have to just sort of wait until he gets here to handle yours. But this applies to you as well for everybody. This is the final plea date. It's your first final plea before me. I know that y'all had a final plea before Judge Dempsey previously, but I gave you all the opportunity post the verdict in the case with some of the co-defendants to negotiate if you chose to, and have a final plea date, if you will. But this will be your last opportunity to enter a negotiated plea in this case, meaning you all in the state have agreed to a recommendation, And you can be assured that if I do not accept that recommendation, that you can withdraw your plea. Now, you can obviously at any point in time enter a non-negotiated guilty plea, and that would mean that you decide to plead guilty, and the state will make a recommendation as to sentence. Your attorneys will make a recommendation as to sentence, and it will be entirely up to the court to sentence. Could be above or below what any of the recommendations are, could be exactly what one of the recommendations is, but as long as it is within what is permitted by the statutes. And then, of course, you have the right and opportunity to proceed to trial on the case as well. Does everybody understand that?
Yes, Your Honor.
Okay. All right. So, Mr. Mender, you have this case pending, and you have another case pending as well. Is that right?
And Your Honor, so we were going to respectfully request to hold our announcement and to have an opportunity to approach the court at the bench at whenever convenient before we move forward with the final.
All right. So I will come back to y'all. So, Mr. Garlington and Mr. Mondelli and Mr. Abadi, can you put the offer on the record for Mr. Garlington?
Yes, Your Honor. Your Honor, on December 9th of 2024, the offer was relayed to counsel for Mr. Garlington as it relates to the possibility of tendering a guilty plea. The recommendation from the state was for the defendant to plead to count 1, conspiracy to commit RICO, count 49, which is the murder count, but it be reduced to the lesser included offense of voluntary manslaughter, and him to plead to count 50, which is participation in criminal street gang activity, and then count 54, possession of a firearm during the commission of a felony, with a global sentence of 30 all parolable time.
All right. And as a part of that plea offer, you all were going to null cross 40, 42, 43, and 51. Is that right?
That is correct, Judge.
All right. All right. And Ms. Rondelli, you discussed with your client the potential sentences that could be faced if he goes to trial and is convicted of all counts.
Yes, Judge, we've spoken extensively about potential risks of going to trial. I conveyed the offer to Mr. Garlington on December 10th, and we have had some discussions with Mr. Abadi since then. We are not in a position to accept the offer to be placed on the record, although we reject that offer. I will state that there are further discussions that are taking place. We understand the court's admonition, though, about any risks that happen.
Yeah, and y'all can certainly present a joint recommendation. It's just not going to be negotiated per se at that point, in that you would have a right to withdraw the plea if the court didn't sentence in accord with that. But I mean, I will say, and this is certainly no guarantee, but I think across the however many years I've been on the bench now, I typically still, if there is a joint recommendation, certainly take that into account, and fairly often probably sentence in accord with that, but that is certainly not a guarantee. So, Mr. Abadi, would you be able to put on the record
Plus,
you understand that, Mr. Let me say another thing as well. I know that there was a not guilty or a not guilty verdict for most of the counts that faced the two defendants who proceeded all the way through to jury verdict. A trial for any of the four of you would be before a different jury. I would suspect that a lot of the evidence would be the same. The way it is presented might not be the same. I I don't know, state's sort of story, theory, if you will, might or might not be the same. And the ultimate outcome might or might not be the same. And I'll tell you, and I'm sure that all of your attorneys have told y'all, that acquittals with a jury are a rarity. So just keep that in mind. It does not mean that the same thing would happen to you. Y'all, you know, we've got a different prosecutor at the table who I hope would stay through the trial of the case. And it just is probably going to look a lot different. There's also a different judge at the beginning. So just keep that in mind, but I understand that for now y'all will be rejecting that offer. All right, so we've got Mr. Epinger, and I know Mr. Epinger still has a motion pending. I will tell, and Mr. Johnson, you should now have all of the transcripts from the main witnesses who testified around the 2 attempted murder counts at trial. And if we are not having a plea today, I'm obviously we're not going to have that hearing today, but I would be interested in going ahead and getting that scheduled. And I will say that I have heard the testimony as it was presented at the last trial, and I have seen the videos. I don't know what might be presented at the immunity motion, but I'm fairly certain that those 2 videos would be presented again, and I'm already familiar with that, as are y'all, having had it in discovery for a long time now. But we're going to go ahead with the final plea now. So even though that motion is still pending, any plea that you might be interested in tendering at some further point in the case, if you ever decide to do that, would be non-negotiated. Just
understood, Your Honor.
Mr. Epinger, you understand that as well? Okay. All right. So, Mr. Body, can you put on the record what the offer tendered to Mr. Epinger was, please?
Yes, Your Honor. The state's offer as it relates to Mr. Epinger was a global sentence of life imprisonment as it relates to the armed robbery and everything else to run concurrent on this indictment. That sentence to run consecutive to the time he's currently serving in DOC custody, Your Honor.
All right.
Mr. Epinger is facing a minimum of a life sentence and a maximum of 2 consecutive life sentences plus 145 years, Your Honor.
And I don't, this is just my quick count, but Mr. Epinger is facing approximately 15 different felony charges on this indictment. Is that right?
That is correct, Your Honor.
All right. And if he were to proceed to trial and be convicted of all counts, in addition to everything running consecutively so that it would be, I'm sorry, I think you said 2 life sentences plus 100 and how many?
165 years.
165 years. That time could also be run consecutively to the time that Mr. Epinger is already serving on whatever he's convicted of already. So have you explained that, Mr. Johnson, to Mr. Epinger?
Yes, Your Honor.
You understand that, Mr. Epinger? Okay. All right. And was there something else you wanted to say?
No, just based on the circumstances, I came to the podium
Okay.
to make my announcement. But given the state's offer, Your Honor, at this time we would reject that offer based on our view and our view of the evidence in this particular case.
All right.
So, yes, we would reject that matter and like to proceed to trial.
All right. And once I get through everybody, or maybe everybody we can get through right now, I'll talk about trial dates. And I'll talk with y'all first about in the immunity hearing date as well. All right. Thank you.
Your Honor, I believe that motion can be held as close to trial as possible.
Well, I mean, it could be, but I'm not interested in doing that. I'm interested in getting that taken care of as soon as possible.
Thank you, Your Honor.
All right. Not December, though. Not that soon. Okay. So, have we covered everybody other than Mr. Mender at this point? Yes. All right. So, let's talk about then the number of witnesses. I would think maybe about 4 or so for the immunity motion.
Statement of no witnesses.
None? Okay.
Your Honor, as far as witnesses in the case, I believe the only witness that may be necessary is the
You can pick it up. It's not.
Is the complaining officer, Your Honor. That would probably be
Okay. Well, there are 2 officers who got shot.
Well, actually, there's only one who got shot. There's another.
Well, one who got shot at and one who got shot. You're right. I stand corrected on that.
So
your motion is just with regard to the one who got shot?
no, Your Honor.
I didn't think so.
No, it is related
Okay.
to both, but the other witness is not necessarily important for the
Okay.
motion.
All right. So that should be able to be taken care of in what, 4 hours at most?
I would imagine no more than an hour.
I mean, I'd think 2, but half a day at most, right?
I don't even think it'll take that long, Your Honor.
Okay. All right. So let's go ahead and get that scheduled then.
I guess I would have my inquiry with the court and counsel would be, it's the burden of the defendant to show that he's acting in self-defense. Typically, you don't call the complaining witness or the victim to establish your intent and how you're acting in self-defense.
I mean, if he wants, whoever he wants to call, he can call. And I get that. So do you think you'd be calling your client? Because it sounds like the state does not intend to call any witnesses.
Understood, Your Honor. It may be a situation where I may call my client
Okay.
after discussion with him, and it may be a situation where we may the calling of the witnesses is just necessary for the introduction of the video, and we can make arguments based on that, Your Honor.
Okay. So let's look at sometime the week of January 13th.
It's fine with the state. If it's just the video, the state would stipulate to the video coming in, Your Honor, making a...
Okay. All right. Did you? I don't know if you heard that, Mr. Johnson. If it's just the video, then the state would stipulate to it coming in. I think there were. All right. Let's do 10 a.m. January 13th.
Your Honor, I did file a response.
Yes, I saw that. Thank you. I appreciate that. All right. And then with regard to the trial, we're at this point looking at potentially 4 defendants for this trial. Does the state have, the last time I asked, we still were facing 11 defendants. So do y'all have a revised estimate as to the time it would take to present the state's case?
I think it would be less than 90 days, but in an abundance of caution, instead of overpromising, I would say at the most 90 days.
All right. And when you say 90 days, you mean from the time we start presenting evidence till the time the state rests would be 3 months' time, not 90 days of trial time, right? Okay. Just making sure. All right. And then obviously the defense would evaluate the state's case before determining whether they wish to present evidence. But any general idea what anybody thinks might get added on?
On behalf of Mr. Mender, if Mr. Mender was to go to trial, we would want 1 witness, and it would be, we would need a production.
Okay.
Judge, I don't anticipate any witnesses.
Okay. Mr. Johnson, And I'm not holding you to it now, I'm just trying to get kind of an estimate.
Your Honor, based on our view of the evidence.
I need you to pick up that mic, I can't hear you.
Based on our view of the evidence, Your Honor, I do not believe that we'll have any witnesses for Mr. Epinger.
Okay, and obviously that's assuming that it proceeds past the immunity motion. All right, and then I'll hear from Mr. Dark. But okay, so we're talking about probably still roughly 3 months. So 3 months is probably an overestimate on the state's case. Okay, so in terms of picking the jury, do y'all want to do jury questionnaires, or do you just want to have people in and do it all live?
Judge, it is a question as to how many jurors we anticipate calling in.
So, I mean, if this were a typical case, I wouldn't call more than 72, but
My experience is that they are more comfortable being honest and letting their thoughts come out in the questionnaire.
in the questionnaire. Hey, excuse me. All right, so I know that at least as sort of a pilot project, Jury Services here in Fulton has some, I don't know, tablet type things that jurors can answer the questionnaire electronically, but I think they basically like come in but just sit and answer the questionnaire, and then we have them back another day for follow-up. So we could do something like that if everybody's amenable to that. Okay, and have y'all thought at all, I guess did y'all already go through at least part of jury selection in this
We did.
prior iteration? Some of you did and some of you didn't, right? All right, so, I mean, I would need to know what type questions y'all want. So can y'all by, let's say, January 20th, have the potential questions that you all want asked?
And I think the previous questionnaire was sufficient, but it was redundant.
Well, we don't want redundancy. I'm not a fan. Well, redundancy every once in a while is a good idea, but I want to be efficient. Okay, so I'll pull and look at the last questionnaire, and if, y'all do the same, and if there are ones that you think we can strike, and any that you think we need to add, if y'all can just let me know that, and maybe we'll have, let's look and see what the 20th looks like. Maybe we can have, the 20th is the MLK holiday, so let's not do it that day. Let's do the 17th, which is the Friday before. Why don't we plan to just have like a status on, let's say 10 a.m. on the 17th of January? Where we can, so if y'all would submit whatever kind of additions, deletions you would like to the jury questionnaire by close of business on the 16th. We'll meet on the 17th for a status. And
Judge, is that everyone in this courtroom on the 17th?
everyone who is still wanting to proceed to trial at that point in time. And in addition, Mr. Dark. And then I know the state had proposed, did y'all say February 24th as the beginning of trial?
Yes, Judge.
I had been thinking, I mean, is that a trial day for us?
Judge,
We can,
we could make it one, but
Mr. Dark's place. He had sent an email after I had filed my motion. Apparently he may have leave filed on that day. I can't.
Let's find out whether he does. Because if it's not filed in this case, it doesn't really matter. This person, can you see if you can find it? Anybody else have any kind of, sorry.
Anybody else have any kind of an already filed conflict with beginning trial that day? Okay.
I have leads, but
Is it already filed?
they are filed.
Okay.
But things can be rescheduled, so that's not an issue.
All right.
Does the court expect to have jury filling out questionnaires prior to the day that we're starting?
I mean,
Because there's a couple things that can happen.
yeah.
So one is the questionnaire, and with Mr. Abadi at the table, it might be more efficient, but the questionnaires give rise for strikes for cause outdate. So if we can agree to ones that are clear, then we can at least dwindle down and not have to waste time on whether or not.
Well, they're clearly going to be stricken for cause.
Right. And I think those things, like, they can get the questionnaires done, we can.
Yeah, I mean, I definitely think we need to get the questionnaires back before we have them back for the, day of actual questioning, or days, I don't know, of actual questioning. So,
Reading of the indictment is a day of us sitting there, or was a day, multiple days.
Let's see what we can.
I mean, it may be that the state's not intending to go forward with however many overt acts it was before, 213 or
That's
something.
unlikely.
They may winnow down the indictment. Could you have that done before the 16th as well, or by close of business on the 16th? Okay. And I was going to say there's no reason to read the substantive counts that are against defendants other than these four or whomever it ends up being. But they may be overt acts anyway, but we wouldn't need to read the counts, even if they were included as overt acts. So, it would be a redacted indictment that we read.
Yes, sir.
But yeah, we'll talk in more detail on the on the 17th about that, what date we're going to have jurors in, how many jurors we think we need to call, things like that. Okay. And then I know there are no, other than the immunity motion, no outstanding motions, but are there going to be motions in limine, evidentiary kind of things that have not already been resolved? I need y'all to think about that and get all of those filed by January 16th as well. Okay. Actually, if y'all could get those filed by the 15th, that would be good, and then I could be taking the 16th to start looking at them, and maybe we could talk through some of them on the 17th.
Can we have a deadline for a discovery drop-off link?
I would sincerely hope that all the discovery has been shared by now.
I know they're working on consolidating some of the new stuff that came out as it relates to during the trial.
Okay.
But that shouldn't take very long. I know Mr. Dark has received the majority of, it's just taken a minute, it's over 8 terabytes file for Mr. Dark. So that's been the focus. But I will make sure.
Yeah, so if you, the state, could put together your narrowed, cold, focused discovery.
It'll be, yes.
Can you get that? When do you think you could get that to all the defendants? Because even if they have everything, they'd probably rather have the smaller universe of things.
first week of January. Is that appropriate?
Yeah, that works. All right, so that would be, gotta find my calendar again. January 3rd. By close of business, January 3rd. All right, anything else we need to think about right now? All right, everybody else, I'm going to go ahead and release Mr. Abadi. Obviously, you'll need to stick around, and we had an anticipated 11:30 arrival time for Mr. Dark, so we'll hold on to Mr. McMullen as well, and then once we have Mr. Dark, we'll reconvene for his final plea and to discuss with him the deadlines we've set. Was there something else, Ms. Fagan? Oh, sure, yes, I'm sorry, you did mention that.